Welcome to Devine Intervention, shedding light on Illinois property tax.
Hello, and welcome to Devine Intervention, shedding light on Illinois property tax. I'm Nora Devine, a property tax attorney who has spent the last 2 decades representing owners across Illinois, from single parcel investors to statewide portfolios. Today's guest is Sally Wagenmaker, partner at Wagenmaker and Oberly LLC, a law firm serving nonprofit and tax-exempt organizations across the country. Sally provides legal counsel in corporate, tax, employment, and real estate matters for churches, schools, social service providers, and other charitable institutions. In today's episode, we're focusing on property tax exemptions for nonprofits in Illinois, including churches, schools, health clinics, and charitable organizations. These exemptions can provide massive tax savings, but qualifying for these exemptions can be trickier than you might have thought. Sally, welcome to the show.
Thank you so much, Nora. Glad to be here.
Yeah, I've known you a long time. Tell us about how you got into this practice area.
Oh, wonderful. Yes. So I got started in my legal career doing employment law, of all things, morphed into legal aid, and then transitioned about 20 years ago into representing not-for-profit organizations. And property tax exemptions are really one of the key benefits that not-for-profits that can qualify for that benefit really want and should have, really for optimal stewardship of their resources.
Great. So what types of nonprofit organizations are going to be eligible for property tax exemptions? Is it like if you have a 501c3, boom, everything you own is tax exempt? Is it that easy?
Right. Some people think that having the 501c3 federal tax exempt status is sufficient, but it's not. Property tax exemption is a creature of state law. So at a minimum, you want to have that 501c3 status. That means churches or other houses of worship, which are automatically tax exempt under 501c3, as well as schools and other educational institutions. But that's really a term of art. The school educational exemption needs to be some sort of school that relieves a government burden. And we can unpack that a little bit later if you'd like. And then the third bucket is charitable, which is just really everything else: social service organizations, food pantries, all kinds of organizations that provide goods and services on a charitable basis.
So I met someone in passing last week who said that they do, it's a nonprofit, they do roller derby. They said that they're very competitive, and they were thinking maybe they shouldn't have to pay property tax. And so I was saying to them, well, you might want to talk to Sally, because I don't think it's a matter of, just being a not-for-profit. And they were like, but we don't make money, we barely break even. And I said, well, I think there's more to it than that. But what do you say to these kinds of folks that are saying, like, we are a nonprofit, we're not geared toward making a profit, but we don't want to pay property tax? How do we fit ourselves into this charitable use exemption?
Right. That's a great example, because I think, first of all, being a nonprofit, that's a matter of state law as well. So you can be a nonprofit social club, which might be a roller derby. You could be a nonprofit social welfare organization, which oftentimes these days is mostly focused on lobbying. There's a whole plethora of nonprofits. You could be a trade association, but really only the 501c3 category could qualify. So right off the cuff, if you say roller derby, that does not sound charitable to me. It could be educational, like learn how to roller skate, but that's not relieving a government burden. So you're not going to get an educational exemption. It certainly doesn't sound religious, at least, from the first get-go. So if you're going to get charitable exemption, it should probably have some sort of component like serving underserved youth, not charging fees, or if you charge fees, doing so in some sort of generous capacity, so that you can say to the government, in some way, we're doing some sort of good that qualifies not only for 501c3 status, but also in some way is doing some sort of charitable activities that fits better with the state regime.
Okay, so what kind of things would they have to gather if they were going to prepare to apply?
Sure. Our law firm has a plethora of resources, and I will just highlight two so that people can go and check these out. They're not DIY articles, but they're very helpful. The first article is called Applying for Property Tax Exemption. We just published it last month. It has a list of all the documentation that is needed. I'll go through that in a little bit. The other is actually a series called Making Room. So if you go to our website, Wagenmaker and Oberly, and just type in Applying for Property Tax Exemption or Making Room, you'll get to those articles that give a lot of guidance. Under the Applying for Property Tax Exemption, essentially what you want to do is show qualified ownership and qualified usage. So ownership would be a 501c3 letter, articles of incorporation, bylaws, things that show the trappings of your nonprofit status, and then the usage. Typically, the key document we provide is the affidavit of use that goes along with a form. The form is very perfunctory and it's government prescribed. The affidavit of use explains who the organization is, what they do, how these other documents are connected. For example, applications require financials, a revenue and expense statement, because the words will paint the story of this qualified exemption status, and then the numbers should back that up by showing, for example, that you're mostly supported by charitable contributions, or that you have charitable contributions plus, for example, fees paid for school or for other purposes that are not showing a view to profit. A view to profit is verboten under the state statute, and it is a conclusion. It is not enough to say we get some money in, but we're not operated with a view to profit. What we want to do is make it easy for the government to say yes, and that yes is yes, you are qualified for exempt purposes. You do not operate with a view to profit, particularly with respect to what kind of revenues you're receiving.
So the denials that you see, are they denied because of this idea of the view to profit, or because their use isn't exclusively charitable enough, or what are the typical denial reasons?
Right. Yeah. So the denial, basically, when you apply for property tax exemption, you apply first to the County Board of Review, and then that's kind of the recommendation level. The second level, the ultimate, is the Illinois Department of Revenue, and they're the ones who ultimately say yes or no. And so when we see rejections or questions, sometimes at the county level, they may ask some questions. And the best description I've ever heard is that it's a winnowing process. So you're winnowing through, do you have enough documentation? Is there any problem? The county could actually help in some ways by saying, we don't see financials. Where are your financials? But typically where I see the rejections are maybe some sort of initial problem, like a trade association that applies, they're just not going to get it, or the wrong kind of classification. What's one of the most common is a church or other religious type of organization that applies for childcare exemption based on their childcare program. Well, childcare does not relieve a burden of government, although there may be wonderful government benefits or government-related benefits, but the state does not have an obligation to provide childcare, nor is childcare ever going to fit in the religious bucket. So for a church to apply for religious exemption using childcare as its activity, for which it charges lots of fees with very little fee waivers or reductions, they're probably going to get a no. And one of the most interesting examples I've seen recently, I would say that the government is getting more and more miserly, grumpy, skeptical, cynical, whatever you want to call it. The government really doesn't want to give these exemptions. I think that's the upshot. So recently, I've in my 20 years I've done this, I've always recommended that my clients have something in their bylaws that say that there will be generous fee waivers and reductions, because one of the elements is that you make your charitable benefits widely available to all without undue obstacles. So you better prove generous fee waivers and reductions. So I had a client, as one of its many things it did to get ready for property tax exemption, we updated the bylaws, and now the bylaws have a provision, generous provision of fee waivers and reductions. Well, the Department of Revenue granted exemption, thankfully, but only as of the date of that bylaw update, which I thought was very shocking. I thought that the bylaw update was just one of the indicia of charitable qualification, but instead, the government looked at that and said, you're not really charitable until you make that update along with your related practice. So that's an important pointer that those kinds of things should be addressed very carefully.
And you're mentioning now a Department of Revenue ruling or an appellate court case, or what?
That was just for our case, right? It's very hard to find guidance. There are some cases. There's the Provena case, which is very famous. There's a lot of other cases in this area. I would say, again, making it easy for the government to say, yes, it's a facts and circumstances test. You have to prove by clear and convincing evidence with all debatable facts resolved against exemption. That's an Illinois appellate law that guides this standard under the Methodist Old People's Home case and some other important cases by following that. But typically, if you're rejected, you'll be rejected by the Illinois Department of Revenue. You can appeal within the Illinois Department of Revenue, and then there will be ALJ decisions, administrative law decisions, that can be searched on the Illinois Department of Revenue's website, but they technically don't carry any right. However, when you look, I would bet a nickel that of the denials, probably at least 10 to 20% are churches that apply for childcare, and they try to claim religious exemption, and those, they just do not add up. There's technical issues. Another one I've seen over the years, it did go up on appeal and back down, and we finally won because we did it right. There was a school that started a thrift store, and a thrift store can qualify as charitable with a lot of constraints, but because the school applied, the Department of Revenue rejected it, saying only a charitable organization can apply. So there was not qualified ownership. Even though a school is a 501c3, they could not apply successfully for a thrift store property tax exemption because a thrift store had to be a charitable organization, not a school. Very technical.
Interesting. So how does all that square with like a parochial school that has pre-K 3 through 8th grade, and like half of the population of the school is actually in preschool, but they're
That's
exempt,
a
right?
really great question. I think what I would recommend in that case, you start with your best foot forward. So I would really focus on the older grades because that is part of what the school does. And then to the extent that if it's very highly oriented towards preschool, I would encourage anything that's separated out. In other words, you might get only a partial exemption, say 2/3 of the building is used for kindergarten through 8th grade. Maybe you'll only get exemption for the kindergarten through 8th grade portion. I would also really encourage, we just did this for a school with a preschool, where even though the educational exemption, that's one of the easiest ones to get, actually, if you have a school and you have all your other documents, and that's great. But it never hurts to show how wonderful, how you smell sweet, to say it colloquially. In other words, we included a lot of charitable provision of services because we wanted to make it easy for the government to say yes, to say not only is this unqualified educational, but to the extent they might quibble with us or outright reject us based on the preschool activities, look at how wonderful we are. Look at how generous we are with fee waivers and reductions. And you might even want to wait till a good year. We had a child care organization that it took a long time for them to really qualify enough that we were comfortable applying. And, back in our ugly Illinois history, to a certain extent, they were a child care organization that was waiting on government money. So de facto, they ended up giving a lot of charity away. And we picked that year to apply, and it sailed through. They got $35,000 in tax refunds. And ever since then, as far as I know, they've been operating on the same basis. So they still qualify. And that's a really great success story with careful planning and strategic development of their application.
Right. And when do you think is the best time for them to engage in that type of planning? The board members and the church elders and everybody else, obviously, they want to come to you before when?
Yeah, that's a great question. And I want to piggyback that a little bit into some third-party facility usage, because that's really important as well. I think, as lawyers, we are not magical. We do not change the past. And so property taxes are based on the past or the year of the exemption. And if somebody does something wrong, legally, there's nothing we can do to change it. We cannot whitewash it. We can't change the ownership. Years ago, I had a client, I called it my old shoes case, because they had old shoes of being a 501c4, but they did a lot of charitable activities. So we changed their shoes to being a 501c3, but they lost 2 years worth of taxes. There was a great case study, because I think one of the reasons why they got in trouble with the government is because they were advertising on their marquee loud and clear that they're providing space usage to third parties. And I believe, there's no other way I can explain this, but I believe somebody from the assessor's office drove by and saw that sign, and they were making about $15,000 a year in third-party facility usage for their entire space. So regularly used for non-exempt purposes by third parties. And they made about $15,000 a year for 2 years. They got taxed $90,000 for 2 years. Cannot change the past, but we certainly could change the future and address that third-party usage in a better way.
Yes, and a common fact pattern we see is like a charitable use, if it's, whatever it is, if it's a rehab or a SRO, or if it's a church or whatever it is, if they're in a very densely populated area and they have a large parking lot, everybody around is saying,
Right.
I'll give you exorbitant amounts of money to park cars
Yeah.
on this lot. And, what advice would you give to those folks who say, well, that would be attractive. We definitely don't need this much parking.
Sure. Yeah, I think it's worth a careful conversation, and I usually just bounce through the different factors. And again, on our website, Wagenmaker and Oberly, if you type in "making room," that's a 4-part blog series on property tax exemption, advisability of a facility usage policy, if you're going to have a lot of usage, what to put in a facility usage agreement, and then whether there's unrelated business income tax. So I'll unpack that very quickly. And the bottom line is this make good sense? We talked about at the beginning, good stewardship. So I had a client that had a parking lot. Metro wanted to have parking there. Metro may be exempt. This church was exempt, but the usage was not exempt because, it's not a church's
Parking
mission
for
to
a
promote
fee,
Metro.
right, is not
But
charitable
Metro
use.
was going to pay a lot of money. So I said, well, you know what? Count the cost. And if you're going to make a lot of money, wrap in your expected taxes, put it back on the tax rolls, maybe call you to see if you can get a valuation reduction. But you know what? Make a lot of money. Go for it. And then for unrelated business income, that's a federal tax issue. But generally speaking, if it's unrelated, Metro would be regularly carried on. It's parking, not exempt to not related to your exempt purpose. You're going to make money. But you know what? If you have a mortgage, you have to redo the parking lot. In the end, maybe you'll barely have any tax. It's normally taxed at the corporate rate. But otherwise, I think the pitfalls I see are you have a 501c3 owner, you want to be a good steward, you provide parking to somebody else. They don't qualify. They're that daycare that doesn't provide generous fee waivers, or there's some other organization that's just not set up correctly. So you really want to think through it. And also, generally space usage. Is this a good idea? Are they going to tear your stuff up? I mean, I've seen space usage agreement that say no glitter. If you've ever had glitter, you know why they say no glitter. So it can be, and you're going to be roommates. I have a client right now where their boiler went out and they've got another occupant. They're 501c3. We're all going to do great. We're all going to love each other. But guess what? The boiler went out and now the third-party occupant is very upset. They've got all kinds of problems. Has nothing to do with property tax exemption, has everything to do with being roommates and getting along well together. So to really think through that, count all the costs, and appreciate too that property tax exemption is so valuable. So if you've got that parking lot, maybe you want to segregate out, you want to separate and say, these 10 spots can go to that bank next door, but the other 30 spots, we're going to keep the exemption. There's lots of different ways to think about it, but
And you
definitely
can,
in advance.
in my world, we do it all the time. We create a leasehold pin to account for that taxable chunk of parking spots that are going to be going
Sure.
to whoever. And that's easy to create. And, the problem is if they don't pay the tax liability, now there's contractual pursuit of their obligations. And it's, I can see after having this very short talk with you that you do a lot more than just figuring out how to achieve property tax exemptions. It sounds like you're managing a lot more than that. It's relationships. Now you're
Yeah.
roommates. Now you have these contracts that you both have to abide by, and it sounds complicated.
Right. And I think that brings up 2 points that are really important. One is to plan together and plan well. If we think this is a property usage that's going to kick it off the tax rolls or kick it onto the tax rolls, to figure out what that expected liability is, because taxes are payable 1 year in arrears, and good luck chasing somebody down. But by the same token, the other way, we just got property tax exemption approval for 6% of property after chasing down this third-party occupant, getting all of the usage has to be exempt for not only the owner, but the user. And the user was a little bit slow, but that 6%, we found out that was $11,000. So our application was going from 94% to 100%. And now we're going to save $11,000 every year. So I think the client will be very pleased with that. In other words, it can go both ways, getting it back on the tax roll, off the tax roll, but always be attentive to what is the property being used for.
Right. I see. The use is central. Well, thank you for everything. We'll have you back on the show at some point if you're willing to do kind of a round robin of, craziest ideas we've ever heard about something that somebody wanted to make exempt, because I've got 10 on the top of my head right now. And, I probably sent every single one of them your way. But in conclusion, like what do you think is the best thing for anybody to keep in mind if they are wondering if something could be totally exempt from tax?
Yeah, I think it's a very worthwhile question. I think it's worth pursuing, and to be careful about making those assumptions that if it's, the 501c3, more than that, what kind of usage. I think I'm seeing so much, especially post-COVID in good ways, of folks trying to monetize their property by having third-party users, and to just really, really think through that. I was just talking to somebody this weekend who they did an incredibly clever approach to how to make sure they protected their property tax exemption, essentially taking something in-house that was done by a for-profit third-party users will always corrupt your exemption. And they were able to weave that together by careful planning. So we want to plan well. We hope for the best, but we plan for the worst. And that goes for property tax exemption too.
All right. Well, thanks for being here, and thanks to everybody who's listening to Devine Intervention. And if you enjoyed these insights about how nonprofits can navigate property tax exemption with confidence, you should check out Sally's website at wagenmakerlaw.com. And if your organization owns property and wants to explore a property assessment appeal, you can always check out my website, which is www.thedivinelawgroup.com, and you can connect with me on LinkedIn. Be sure to like and subscribe so that you help the show grow and that you can be alerted when we have new content out there. And we'll see you all next time. Sally, thanks so much for joining us.
Yeah, it's a pleasure. Thanks, Nora.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.